Hi, everyone. Attorney Scott Simmons here. I'm one of the attorneys at the Rossen Law Firm here today to present to you trial preparation, strategies for success, how to build a winning case before you step into court. Next slide, please. So this is our firm. These are the other attorneys at our firm. We work at the Rossen Law Firm where we're all partnered attorneys. Our motto is that we help good people when bad things happen so they can achieve their best future. We are a South Florida-based law firm practicing mostly in Broward County, Palm Beach County, and Miami-Dade County with a state and federal practice. Go to the next slide. A little about me. I'm from South Florida, born and raised. I did mock trial all through law school, winning national competitions. And I was a public defender before joining the Rossen Law Firm, where I received multiple not guilty verdicts, including what they call the hat trick award at the Broward County Public Defender's Office, which is 3 not guilties in a row, multiple times. There's my LinkedIn information as well. If you guys want to reach out to us on LinkedIn, you can. And there will be a QR code at the end of the presentation that you can scan to get all of our contact information if you have any other questions or just want to follow up with us. Slide. So preparing for a criminal jury trial. So in order to be successful in trying any type of case, especially a criminal case, preparation is key. The lawyer who knows their case better has an advantage, plain and simple. The lawyer who knows the evidence better has an advantage, plain and simple. The lawyer who knows the law better has an advantage, plain and simple. By knowing all three of those things, you're putting yourself at a strong advantage where even if you have a worse case, you may have a potential of still winning because you are more prepared than your opponent. Oftentimes, especially in state criminal court cases, we are more prepared than the prosecutors when it comes to going to trial. We know our cases better. We know our evidence rules better. And it allows us to win cases that maybe the facts are that we shouldn't have won, or a different prosecutor who spent more time could have beat us, but we're able to win those cases. Next slide. One of the first things you should always look at when you're preparing for a criminal jury trial is the jury instructions. So every state has jury instructions which tell you what the element of each crime is. And in Florida and in other jurisdictions, they also will have specific case law that is specific for that crime, such as defenses or special jury instructions that you can request and things like that. So you want to look at these jury instructions because, one, you want to know what the elements of the crime are. Even if you think you know what they are, if you've never looked at the jury instruction, look at them, make sure you know. It might be an and when it's an or there might be something in there that you're not aware of. And it's the government's burden to prove those elements beyond and to the exclusion of every reasonable doubt. So by knowing what your elements are, you know what the state's weaknesses are. Maybe they have a really strong case on element number 2, but they don't really have any evidence on number 1. And now you know how to target your defense and that you're really going to just be focusing on number 1. And it's going to show you what defenses are and what possible objections are throughout that trial. Next slide, please. So a very important thing is to organize your discovery. So depending on the type of case you are is depending how big your discovery is. Some cases, it's just a single page police report and that's all you have. Pretty easy to organize that. Other times you'll have cases where you'll have 10 or 12 officer reports, supplemental reports, body-worn cameras, surveillance cameras. In cases like that, it gets a lot more trickier to be organized in trial. So there's different ways, and not what I do may not work for you, but there's different ways to stay organized. And for trial purposes, what I like to do is have my discovery organized and categorized by witness. So I like to have, if an officer has pieces of evidence attached to him, I like to make sure I have notes of that in his file. I have a manila folder with his reports and anything that's attached to him. So that way, when he's called up for direct examination, I can pull out that folder and I have all the notes that I need. You also want to look at their reports, their depositions, things like that, and notice if there's any inconsistencies that you're going to be using later on for impeachments. Depending on how big the case is, you're going to want to have quick references. So you may just want to have a sticky note explaining what each document is, so that way you know if you're going to need it, what it actually is without having to spend the time of looking through it. So again, it depends. If you're doing a petty theft or a misdemeanor battery, probably not for you, where you're going to have one police report and maybe a couple body cameras. But if you're doing a 2, 3, 4 week long trial, you could be talking about a lot of evidence and a lot of witnesses, and you need to make sure that you organize. So that way you're ready every time that witness takes the stand. Next slide. Another version of that is you also are going to have discovery depositions depending on the type of case it is in your jurisdiction. So in Florida, for misdemeanors, for example, you're not guaranteed to have a deposition, but in our felony cases, we are going to have a deposition. In federal cases, you're not going to have a deposition here in Florida. But if you do have a deposition, you want to make sure you have a clean copy without staples, that you're able to pull out a specific page. You want to make sure that you have a clean copy, because you don't want to make sure you have any notes on it or anything like that you may be using in cross-examination. And you want to make sure you have a tab ready with page and line numbers of what you know a witness may get impeached on. You always want to be ready, so that way you can, one, pull out the deposition cleanly, give a copy to the opposing counsel, let them know where you're reporting to, and then so you can show it to the witness. If you don't have your page and line numbers ready, you're going to have to spend time flipping through the deposition, and you're going to lose effectiveness of that cross-examination and of that impeachment just by not knowing the page and line number already. And especially with PDF formats now, it's so easy to do Control F and find these things, or even have AI point out these inconsistencies and have a page and line number ready to go before you're in trial. This is all things you want to do in the weeks leading up to trial. Next slide. So defense exhibits and digital evidence. So you always want to make sure, one, if you are entering any evidence, that you filed a discovery with the state, that they have a copy of it, so that way you can actually use your discovery. If you didn't send it over to them, a lot of times you're not going to be able to use that discovery. You want to make sure that it's admissible. And if it's not admissible and you know it's going to be a fight, be prepared for that fight. Go look up case law ahead of time. Don't wait for the moment to hear that hearsay or relevancy objection. Be prepared for it. Come with a clean copy of the case law. Give it to the judge. Explain to them why this is admissible. You also want to go through all the digital evidence in a case. Something that you may not think is important, such as your client stating the back of a police car. There could be one statement in there that you didn't pay attention to, and the state's going to introduce that, and you don't want it to be the first time you're hearing it is when they introduce it. So you want to make sure you go through all that digital evidence, and you want to make sure you have a ways to introduce that digital evidence. So every courtroom is different. Every jurisdiction is different. A lot of times, you need to plug in your computer to the courtroom system, which requires you to have a special device, and a different extender depending on your laptop. You want to make sure you have that. You want to make sure you have USBs, so you actually have a copy. A lot of times we have our digital evidence just on our computer, but you have to actually give the clerk a physical copy to introduce as the evidence. So I always keep a couple blank USB drives in my backpack, in my briefcase, ready for trial, just in case there's a piece of evidence that I wasn't planning on introducing that I then later have to introduce. So that way there doesn't have to be a delay. There doesn't have to be a fight. You don't have to have a law clerk or a partner go run out to find you a USB so you can do it. You just want to have a couple clean ones with you. So that way you're always ready to introduce digital evidence if you need to. So you always want to be able to anticipate the state's witness. Depending on your jurisdiction, they're gonna send you, and if it's federal or not, they're gonna send you a witness list. In most state court cases, you're gonna get a witness list. You want to be able to go through those witness lists. You should know every name on there. Go over them. Make sure you understand what each witness is probably going to testify about, and figure out what weaknesses or biases you can bring out in cross-examination. That's the key to a cross-examination. Each witness is going to have a different theme. Each witness is going to have a different way that you could win that cross-examination. And you don't want that theme or those goals to be decided during the trial. You want to think about that in advance of trial. You want to be prepared. You want to know who those witnesses are and potentially the order that those witnesses are probably going to come in. Next slide. And one of the most important conversations you're going to have with your client before trial is whether or not your client's going to testify. Client testifying or not testifying is not our decision. It is the client's decision. But it is a conversation that needs to be had, not after the state rests their case where you do it in front of a judge, but you need to have this conversation weeks, months before trial. So that way you can prepare your client to testify and you can intelligently discuss the pros and cons. There's lots of cases where there's benefits of a client testifying, that the evidence that you need can only come out of their mouth. There's no other witness that could testify to it. Or even that your client's just a personable person, and you think that if the jury gets to hear from them, even if it's basically saying the same things that you were able to say in cross-examination, the jury is going to tend to like your client more by him being on the stand or her being on the stand. And then you obviously have the negative, which is cross-examination. Could your client be disliked based off what happens on cross-examination? Are they going to come off like a jerk? Are they going to come off unreasonable? Is there any prior bad acts or character evidence or felony convictions that are going to come out if your client testifies? These are all things that you need to discuss. Are there things that you don't think your client can answer correctly without opening the door? So do you trust that your client will be able to stay on that narrow path, answer the questions asked and only that, or are they going to open a loose can of worms and go into something that you'd rather they don't go into? And then that's something you got to explain to them, and so that way they can make the best decision. The example I always give my clients, and I always give the jury in voir dire, which Susan Lawson will be going over with you guys, is I always think about a quarterback taking a knee in football, which is, if you already won the game, why would you risk running another play? We've all seen at least one football game where a player decides to run a play where they've already won and they fumble, they throw an interception, something bad happens, the other team gets the ball, scores, and wins. So if you know you've already won the case, or you believe that you've won the case, because you'll never know for sure, why take the chance? Why run another play when you can just take the knee and bring the case out to the jury? Again, depending on your case, you need to prepare your witnesses. Different cases, obviously, as defense attorneys, sometimes we don't call any witnesses. Other cases, we have multiple witnesses you need to call. First, you want to make sure that you've listed those witnesses, that you've subpoenaed them, and that you know that they're actually available to come testify at trial. When you're picking your trial dates, it's something you definitely want to check with all your witnesses. Hey, do you have any out-of-town trips? Do you have anything big planned? You want to make sure your witnesses are actually available, so that way you can actually have them. If you have any experts, you want to make sure that you disclose them as experts. You want to make sure that you gave a copy of their CV and their reports, so that way you're actually able to have your expert testify. These are all things you need to do as a checklist, depending on the type of case you're trying, to make sure that you're prepared for trial. Next slide. So all of that was about how to stay organized, how to make sure you're doing the right things to prepare for trial. Now, this next part is the pretrial motion practice. We're not going to be talking about motions to suppress or motions to dismiss, because this would get way too long. We're going to really specifically be talking about motions for judicial notice and motions in limine, and leave it at those two motions. Obviously, you should be filing motions to suppress or motions to dismiss before trial. Again, those would be an entire presentation on themselves, and there's plenty of different reasons why you could file all of those motions. So let's jump into the next topic. Next slide, please. So what is a motion in limine? A motion in limine is a motion to include or exclude improper evidence before trial. Usually, people are not filing a motions in limine to include evidence before trial, but you can, especially as a strategy to try not to go to trial. Sometimes if you file a motion in limine for an inclusion of evidence and it's granted, the state now knows that they have a weaker case, they'll make you a better offer, things like that. Same with motions in limine to exclude evidence. If you get a good ruling for a motion in limine to exclude evidence, again, that could change your pretrial negotiations and things like that. So you need to be methodical on when you're filing these and when you want them heard. You also need to check your judges' divisions and procedures. Different judges will hear these motions the day of trial, where other judges will require you to have them set a week, 2 weeks, even a month before trial, and will say that you've waived your motion in limine if you have not had it heard before trial. Now, even if your motion in limine is waived before trial, you can still make a contemporaneous objection during the trial. I see I have a question. 1 second. How should defense attorneys balance the need to exclude improper evidence with the risk of drawing the court's or jury's attention to potentially damaging issues? Great question. Well, one for the jury is all motions in limine should be done outside the presence of the jury. And the more damaging you think it is, the more you want to do a motion in limine. So if you do a pretrial motion in limine on, let's say, a bad act or character evidence like that, the jury's never even going to get to hear it. They're never even going to know that it happens if you get it granted. If you wait for the question to be asked, well, is this your first arrest? Have you ever been convicted before? And then you object? Well, the cat's out of the bag. The jury's already heard the question. They heard you object. They know that there's something there that they're now not being told. So you definitely want to use your motions in limine to think about that negative information that can come in and make sure you're excluding it preventatively. Now, the judge is going to obviously get to know it, but there's nothing you can do to avoid that. If you win the trial, the judge knowing it doesn't matter because the judge won't be there for sentencing. But even if your client is found guilty, it's your ethical duty that if you believe there's damaging evidence that you can keep out, that you must fight to keep it out. If there's a reason why you're not going to, you need to have a very long conversation with your client, explaining that and having them waive that right that you're not going to fight this evidence. Can't really think of an example where I would want to do that. I'm most likely filing that motion to eliminate and making that fight, or I'm strategically not filing the motion to eliminate and I'm doing a contemporaneous objection. And the reason to do a contemporaneous objection is you know that the evidence could be admissible, but with the evidence that the state has given you at this time, it's not admissible. So what are examples of that? Well, maybe they didn't file the business record exception. So they plan on introducing a document such as a medical record or a business record, and they didn't file the proper paperwork. Well, that document comes in with the paperwork, but without it, it doesn't come in. So then maybe you don't file a motion to eliminate. But a lot of statements where you do want to file motions to eliminate are going to include hearsay statements and character evidence and uncharged crimes. You want to be as specific as possible. You need to remember that oftentimes the judge is not going to know a lot about your case. They're only going to really know what the charge is and what you've told them throughout calendar call or your normal court appearances. And they're not going to know a lot more than that. So you want to give them all the detail they need. Who is the witness? Where was the statement made? Who was it made to? And why is it hearsay? If you have a case law on it, obviously you always want to provide them case law. Same for the character evidence or the uncharged crimes. You need to give the judge all the tools to grant the motion in your favor. If you don't, they're going to most likely either deny it or defer, and now you're back to having to do a contemporaneous objection. Even if your motion to eliminate is denied, you still need to do a contemporaneous objection when the evidence comes in to preserve that issue for appeal. But you want to think about these motions in limine. When you're going through your discovery, you always want to, I make a little note on the left-hand margin, motion in limine. So that way I know if I'm watching a body cam or listening to a statement, I know, okay, that's something I need to file a motion in limine on. And I always put the specific timestamps for my motions in limine because I want the judge to know, especially if you're talking about a 3-hour-long body camera, for the motion to eliminate, they don't want to have to sit there and click through the video to figure out what part you're talking about. You want to give them the exact moment of that video or the exact reference in the deposition. So that way the judge has all the evidence they need in order to rule on your motion to eliminate. Again, the common things are hearsay statements. If you know a witness is not going to be available, so you know that the statement's going to be hearsay, you can address that in a motion to eliminate. Improper character evidence. So a lot of victims will, testify about prior actions with your clients that has nothing to do with this case. You want to make sure all of that's out. And uncharged crimes. A lot of times you'll see that maybe there was behavior that could have been criminally charged but wasn't, or you severed charges or things like that. You want to make sure that there's absolutely no mention of any uncharged crimes. And next slide. So I feel like everyone files a motion in limine at least at one point. Oh, there's another question. How can a motion in limine preemptively limit prosecutorial attacks that rely on emotional appeal rather than legal merit? That's a good question. So it really depends on your judge and your jurisdiction. So there are people who will do case law that you can't call, the victim a victim. Typically, you're going to lose that one depending on the case. Again, there's exceptions to the generic rule. You want to look at it for closing arguments. There's a lot of case law and closing arguments that state attorneys are not allowed to make an emotional appeal to the jury. If you have a belief that they're going to do that, you can put that in your motion in limine. A lot of judges aren't going to just rule on standard issues of law, though. They're going to wait for it to happen and say, well, you're both going to follow the law, you're attorneys. But you always want to have those types of cases, especially if you're worried about it. I always have like a closing argument that has about 28 cases on it that are the most common objections in closing argument, which do go to that emotional appeal. Oftentimes, if there's a specific issue, obviously look up the case law, see if it applies. If it does, file a motion to eliminate. A lot of times you can do that depending on what the specific issue is. So thank you for that question. Motions for judicial notice. So a lot of times people file motions to eliminate. I think almost every trial the defense will file at least a boilerplate motion in limine, whether it's just invoking the rule of sequestration. But you don't see a lot of motions for judicial notice filed. In Florida, we have 2 statutes that govern judicial notice. All judicial notice really is you're asking the court to take note of something and tell the jury that this is a fact. So you can move for judicial notice on anything, whether it's granted or not is depending on what evidence you're asking for it to be. So in Florida, there's a mandatory and a discretionary. The mandatory is the law, court rules, and the appellate decisions. Not a lot that you'll really ask for in a motion for judicial notice, but again, depending on what your case is, those may be applicable. And then you have discretionary judicial notice. So you have municipal ordinances, official government records, weather reports, historical data. I've used all of these. So I had a DUI trial, for example, where there was a boot on our client's car and the car was immobilized based off the boot. Well, we filed a motion for judicial notice to find that the purpose of a boot on a car is to immobilize it. In order to do that, we used government official definitions. So we found multiple different government buildings that defined a boot to be an immobilizing device. And ultimately, the judge ended up granting that, and it really limited the state's case. They made us a better offer, and we actually didn't go to trial based off of that motion for judicial notice. We have another case where a battery occurred, and it's disputed whether or not our client, it was a biker and a jogger, and who's basically was in the wrong area. And we're going to be filing motions for judicial notice because that's the only way you can determine who is in the right area and who's not. I've definitely filed them for weather reports if you want to know if it was raining the day before, if it was cold. These are all things that can be important depending on what your defense strategy is. You're not just filing these to file them, but obviously they need to match the theme of your defense strategy. There's another question. How can attorneys argue for judicial notice when faced with a judge who is reluctant to acknowledge certain discretionary facts? Well, you can't do it for discretionary facts. So even it's discretionary in the sense that the judge doesn't have to grant these ones, even like the weather. We know that it was 75 degrees on this day. That doesn't mean the judge has to grant it and read that in as a stipulation. It's in the judge's discretion to do so. Your best way in making the judge do it is giving them all the evidence that this is a fact. And why are we hiding facts from the jury? Why can't we just do it? But ultimately, you need if that fact is super important to your case, you need to rely on something other than just judicial notice to get that fact in. Depending on what the example is. Again, if it's the weather, you may need to have a meteorologist as your expert witness. Obviously, that's a lot more expensive and time consuming. So definitely try to do the motion for judicial notice. Again, like the motions limine, depending on your trial strategy, this should be filed well in advance, depending on when you need it heard, or you want it filed maybe a month before trial and heard the week of trial or the week before trial. That's all a trial strategy. But if it's one where you think it's going to be really helpful, again, you want to think about, if I file this earlier, is there a better chance that it's going to get me a better offer for this case? And if that's true, then file it earlier, see what happens. You can also ask the state attorney to stipulate. If it's a fact that's not in dispute, oftentimes the state attorney will stipulate to that fact, and then you can have the judge read it in. An important thing to consider with judicial notice is, when do you want this read to the jury? Obviously, the jury doesn't know any facts until after opening, so usually not before opening. Sometimes you want it read right after opening, so it's right in their mind after they know the case and you're being more persuasive. Other times you want to wait for after a witness testifies, or do it in between a direct and cross of a witness. So that's a trial strategy you're going to have to think about to make sure you're asking for that judicial notice to be read to the jury at the right time. Let's go to the next slide. So the next slide is trial strategy and execution. I see another question. What procedural mistakes should attorneys avoid when seeking judicial notice to ensure their motion is granted? Yeah, that's a great question. So motions for judicial notice, you want to make sure you have proof of it. And you don't want the proof to be weak. So you want to make sure you have, if it's something you think is going to be heavily litigated, you want to have multiple different ways of proving it. So for that vehicle immobilization one I told you about, the boot, I listed 10 different government sources, all in Florida, that called a boot an immobilization device or defined it as such. I went to public colleges pages and even discussed in their parking enforcement, what they call it, what it's for, and things like that. Went to the local police department and looked at their things. And then I just used the dictionary. Used Webster Dictionary, which is a non-litigated source usually. And I used all of that. So the judge was very much on our side. And yeah, this is what it's for. I'm going to grant this motion because there's no other, the state's not giving me a different explanation. And I understand why you want this in. So I'm going to agree with it. But she would have been well within her rights to say, I'm denying this motion for judicial notice. and we would have had to make that argument another way. Luckily, in that case, a boot on a car, kind of everybody already realizes the purpose of that is to immobilize a car. But if it's not something that obvious, then you need to have a back door or a second avenue to get in that important evidence. All right, so let's go to the next slide. Now we're going to be talking about trial strategy and execution. So researching case law for trial issues. So we obviously talked about motions in limine. Sometimes there are things that aren't really going to rise up to a motion in limine, but is something you know is going to pop up that you need to have case law for. Anticipate legal challenges and objections. And you always want to do research before. Depending on the issue, you want to make sure you have hard copies for your judge if you're going to need to argue it. Again, knowing your judge is very important. There's some judges who would rather look it up themselves and have their Westlaw open and searching. There's other judges who won't even address the issue until you give them a hard copy of the case law. And then there's judges in between. So you want to know who you're practicing in front of. You want to know what they prefer. You want to know if they're okay with you giving them a highlighted version or if they only want a clean copy, and even how they want you to read case law. I had one judge who I gave a case to, and then I was reading to it, and he goes, "Mr. Simmons, don't read me the case. I'll read it and then make your argument." Okay, judge, not a problem. So he didn't want me reading the case law to him, just doing the analysis and conclusion afterwards. Common examples in criminal defense of issues that you see a lot are dispatch. That dispatch statements can be hearsay, confrontation clause issues, officers testifying about their opinion. So especially like battery cases or cases where the officer didn't actually view the crime, but they're making an opinion because they're making an arrest. You want to make sure you are precluding them from doing that, that officers don't arrest everybody that they investigate. Statements like those are like the generic ones that you'll see that I always have case law on. But then you want to know your specific issues, know what's going to come up, research, look up the crime. It's very important to know that crime and go and search it in Westlaw with a couple ideas that you already have and see if you can find case law, especially with AI now and Westlaw AI and Lexis AI. You're able to look up legal issues very easily before trial to see if there's an issue there and know if you should be doing additional research or if you should have an additional motion even before trial. Next slide. And another question. What are effective techniques for distinguishing unfavorable case law when arguing evidentiary motions before a trial judge? And there's a second case after that one. So it's always important when, especially in trial, when either side I feel like is using case law, no one's really looking at the facts of the case, the charges of the case. They're really just looking for that magical one line that says what they need. So first and foremost, you want to look, is this case law good case law? So has it been overturned or is it still good case law? Is it in a binding jurisdiction or is it only persuasive? Those are the first two things you want to look at. Then you want to distinguish the facts. So you're going to see a lot of different case law comes out depending on what the crime is. And that's a huge thing. And especially what the testimony is. Trials are very fact specific. So you want to try to find different facts and understand why the appellate court ruled the way it did. Now, sometimes it doesn't matter. The facts are what the facts are and your facts are too close. Then obviously you're just trying to find another case that has a better analysis that you think the judge will follow or that is binding instead of a persuasive case. But you always want to try to read the facts of the case. And again, you're getting it quickly to you when you're in trial. So it's easier said than done. If you do one thing and you have your trial partner review that case law and do case law research while you're doing something else. And a second question, what strategies can be employed to subtly introduce favorable case law to a judge without making it obvious to opposing counsel? So great question. I think we all wish we could do that and just before trial give a judge a case law that we don't want to tip our hat to the prosecutor, but unfortunately you can't. Anything you give the judge, you have to give the prosecutor or it's ex parte communications. So that's why you have to decide if, one, is this something you want to file in a motion in limine? Is this something you want to give the judge beforehand? Or are you going to wait for this? Are you going to wait for this issue to come up in the middle of trial and make a contemporaneous objection? If it's something that you don't want to alert opposing counsel to, then obviously a contemporaneous objection is your best bet, so long as the question being asked is not prejudicial enough that even with a sustained objection that you're putting your client in an unfavorable position. But that's really the only way to get the judge case law without alerting the state attorney. Oftentimes, depending on how severe the issue is, they kind of force your hand and you have to file a pretrial motion, or you have to bring it up before the issue presents itself. If you're really kind of in a pickle between those two, the best time to do it, of waiting where you don't want a contemporaneous objection, is to do it right before the witness is called, even without a motion to eliminate. If you know it's going to come out during one witness, then just call that witness right before that witness is called. Say, Judge, can we please speak outside the presence of the jury? Let the jury go back or go sidebar, whichever one, depending on how long it's going to be, and bring up the issue. Judges typically like to have pre-trial rulings or pre-witness rulings, so that way the witness flows better. That way they can give the jury a break all at once instead of having to take 10 breaks while you object to everything and having the jury stand up and go back into the jury deliberation room. So it just depends on what the issue is, on which of the 4 or 5 tactics you're going to choose to use. So let's talk about special jury instructions. What are special jury instructions? Special jury instructions are jury instructions that aren't in the standard jury instructions. They're special. So in Florida, the case law is, so long as there is any evidence that tends to support a rule of law, you are entitled to request a special jury instruction. And when do you use these? You use them when the standard jury instructions don't fit your case. You typically are going to use it on unique defenses, because the more standard self-defense and didn't meet an element, you don't need a special jury instruction for that. If you have something that a special jury instruction qualifies for, you want to make your motion. You want to do a written motion for these. Again, you can do it before trial. If you don't know, and obviously evidence comes out during the trial, you can do it in the middle of trial. I've done both. I filed them weeks before and I filed them in the middle of trial. And the power they have is you are now finding law that, if the judge agrees with you, the judge is going to read as law, and it makes it so much stronger to argue. I mean, think about self-defense, for example. Think about if there was no jury instruction on self-defense and you just had to argue that there was not an intentional or consensual touching. The elements don't help you with that. You need that special jury instruction to say that your client is immune from prosecution if they were acting in self-defense. There's no other great way to make that argument. Burglaries, for example, there's lots of fact-specific jury instructions you can do there. There's things with intent a lot of times that you want a special jury instruction for. I had one, I've done it a couple of times actually, where we have to say that the victim's name is an essential element. So in a domestic violence battery or any kind of battery, the victim's not testifying. Getting the victim's name in as evidence is very difficult for the state, because the only way they know that is typically through hearsay. So asking the judge to find that the victim's name is an essential element of the crime, well, now if the state doesn't prove that, you just gave yourself another element that they can't prove in a way of getting a not guilty. We have another question. We have another 2 questions. How should attorneys respond if the prosecution proposes misleading or legally incorrect jury instructions? Great question. So again, the answer is case law. So if the prosecution is asking for a jury instruction and one, you don't think it applies, even if the case law is sound, it doesn't apply to these sets of facts, then you object on that grounds. 2, you find case law. Special jury instructions is a very highly litigated area, which is why I said that if you believe you have a special jury instruction, file it. It is a way for a case to come back. If your client was found guilty, it is a very good way to get a new trial, because this is an area that, especially for the defense, that deference is given to us, that if we ask for a special jury instruction and the law supports it, that we should get it. So you want to file these motions. You want to make sure the law is on your side. And if it's not, and the prosecutor is doing it, which I will say is more rare, I haven't had a lot of times where I've seen a prosecutor file a motion for special jury instruction, but obviously you want to go through their case law and find better case law than them. How can jury instructions be tailored to highlight weaknesses in the prosecutor's case without appearing overly biased? Well, the great thing about the special jury instruction is the jury is not going to know it's a special jury instruction. When the judge reads the instructions, he's not saying, and now I'm reading you the special jury instruction that the state fought against, but the defense, after 3 hours of argument, I was forced to rule it. He's just going to, between page 1 and page 4, is somewhere in there is going to be your jury instruction, wherever the judge deems fit or wherever you guys agree that it belongs. So it shouldn't come up as biased at all, because no one's going to know your request to have it in there. The jury's just going to see it as law. And then you get to hold that law up in your closing argument and explain how it finds your client not guilty, or how it dramatically affects your case. So again, these are very case-specific, fact-specific issues. There's lots of case law on every single charge. Really, if you think you have one and you're not sure, just type in the statute and special jury instruction, see what comes up, and see if you have anything that applies to you. Opening statement. So a lot of trial preparation is different for each person. So depending on what you prepare and what you don't prepare, I know a lot of people that they like to have every single word of their opening statement written out. I know some people that go up there and they kind of wing it other than knowing they know what they have to say. The thing about opening statements is it's your first time to talk to the jury about the facts of your case. And studies show, especially psychological studies, that if they're on your side after opening statement, that confirmation bias is going to have them on your side throughout the entire trial. So they're going to look at your evidence through a lens that they want to agree with you. If they agree with your opening, they want to agree with you. So you're setting that stage for the jury. You're telling them what your defense is. You're giving them a roadmap. And ultimately, throughout the trial, if you're honest and they're going to enjoy that. They're going to be like, you know what? Scott told me I was going to see this, this, and this. And I wasn't going to see that. And he's right. The state oversold an opening. They told me this was going to be a clear-cut case. And I was 100% going to agree with them. But I'm sitting here and I have more questions than answers. I'm not, Mr. Simmons didn't lie to us. So I'm going to kind of agree with him. So those are the things you want to think about in your opening statements. You don't want to promise too much. You want to make sure you have the important facts that they need to know. And you want to make sure they're not going to be confused. Remember, you don't know who that witness is that's going to take the stand. Oftentimes, that first witness may just be someone to get background information in, and the jury's got no idea what's happening after that first witness takes the stand and crosses, and you cross them. They don't really know what's going on. So you want to make sure in opening statement that the jury is engaged with you, that they're on your side, and that they understand what you're asking them to look for. We have another question. What are the risks of over-promising evidence or testimony opening statements? And how can attorneys avoid making this mistake? So yeah, it's a huge risk. I think you lose a lot of credibility with the jury if you overpromise them. I try not to overpromise. You should know what you need to prove in order to get a not guilty, and you don't promise anything more than that. You don't need to promise them, oh, you're going to hear from an alibi witness if you know you don't have an alibi witness. In a battery trial, you don't need to promise, you're going to find that my client didn't do this or my client acted in self-defense if your argument is just they didn't prove their case beyond a reasonable doubt. You need to know, again, what your argument is. If you're just arguing the burden, make sure they know that. The government's not going to hold up to their burden. You're going to have more questions than answers, and those questions are reasonable doubt. And it's because of the lack of evidence, the conflict of the evidence, and the evidence itself that you're going to have doubt. Sometimes that's all we can say as a defense attorney, and it doesn't get much more than that. The other thing is, if you think you're going to overpromise an opening, another strategy is to waive or defer opening. I really am against this, unless there's a very strategic decision to do so. I think opening statements, your first time to speak to the jury, is so important that you don't want to give that up. Again, unless it's not going to make sense. If you think that your opening statement won't make sense until they hear from the state's witnesses, then you can defer opening. I don't really ever see a time where I'm waiving opening, but those are the times where you'll defer. Again, I'm not a fan usually of deferring. There are cases where it makes sense, but typically I'm not. And there's another question. What role does storytelling play make an opening statement more persuasive to a jury? Huge. Storytelling is what we do. They want to, until there's a witness testifying, everything you're saying, both sides, opening statements, are just stories to them. Until you have evidence to back it up, it's just a story. Obviously, you want your story to have evidence that supports it. Otherwise, in closing, you're going to have that issue of that they're not believing you. But you want to have a good story. And depending on what the story is where you start telling that story. The government might just talk, and the state attorney might start their story the moment your client was arrested or the moment the fight started, when really your story goes back years. Maybe it goes back months. Maybe the victim and the defendant had a relationship that the state didn't highlight and that you need to highlight. So you want to look at what is your theme and what facts need to come out in your theme to tell a story. You don't want to just say these are the 5 uncontested facts in opening all the time. That may be part of your opening, but you want to tell them the story. You want them to be able to paint a picture in their head, and one that they'll be able to agree with you come time at closing argument when you ask for that not guilty verdict that you followed through. How can attorneys craft an opening statement to anticipate and preemptively counter the prosecution's strongest evidence? Well, again, depending on the case, especially in the state level, you should have a lot of the evidence from the state attorney already. So you should kind of know what their argument is. In federal cases, you may not know. That's really going to be up to your client telling you what happened as much as they know what happened. So that way you can counter it. But also the most important thing is, in most jurisdictions, defense gives an opening second, meaning listen to what they say. Listen to what they are highlighting as their biggest strengths. A lot of times they're going to oversell. And you can point that out in your opening. The government just got up here and told you X, Y, and Z, but that's not what the evidence is going to show you, because you're going to hear from this person who's going to show you this. You're going to see this piece of evidence. And in this piece of evidence, you're not going to see what they told you. You're going to see something completely different or something gray. It's not going to be as decisive as they're telling you. It's not going to give you that abiding conviction of guilt. It's not that strong. And that's why we're asking you, keep an open mind. Look at the evidence. You can do things like that. And that's how you can counter the prosecutor's opening statements a lot of times. Next slide, please. So my last slide, this is the final thoughts. I have one more slide. So as I started, effective trial preparation leads to better outcomes. There have been multiple cases in my career where I have won because of a motion to limine. I have won because of a motion for judicial notice. I have won because I knew the evidence better than the state attorney. These are things that matter. You have clients' liberties at stake. You have clients' lives at stake. You need to prepare for trial. Second, you always need to be adaptable in court. You don't always know what the issue is going to be ahead of time. So you need to be able to think on your feet, be able to research while you're in trial or ask for help. I'll always, even my former public defender friends, they'll be in trial and I'll get a text message from them asking a legal question. Not a problem, man. Let me look it up for you and email you a case if I'm available. You got to have help sometimes because it's a lot trying a case. Even with a trial partner, sometimes there's lots of things that come up, but you need to be prepared to think on your feet. For the issues you know about, you need to be prepared for them well in advance. One more. What tactics can an attorney use to uncover undisclosed evidence or improperly withheld discovery materials? Great question. Again, depends on your jurisdiction. In Florida, we call that Brady evidence. So if you believe that the state has exculpatory information, they are required in the state of Florida, if you participated in discovery, to turn that over. And it's a Brady violation. In Florida, if you have a discovery violation during trial, it's called a Richardson hearing. So you ask the judge if you believe that something came out throughout the trial, such as an officer testified, yeah, I did this, and it wasn't in his report, and you know it should have been. You can always ask for a Richardson. The judge will conduct a Richardson in Florida, that's what it's called, to decide whether or not a discovery violation occurred. Was it willful or was it inadvertent? And was it material or not? Based off of those three things, the judge can then give you a remedy. A lot of times the remedy can be a mistrial. Typically the remedy is not going to be excluding that evidence, depending on what it is. So you always want to ask for a Richardson. You want to preserve your record on appeal, but you also want to be mindful that sometimes it's going to be a mistrial and that's all you really have as your remedy. And you got to talk to your client about the pros and cons of taking a mistrial compared to waiving it. Typically, I lean on side of taking a mistrial unless there's something really good that happened in this case that you don't think will happen again. We got a couple more questions. Okay, second. When deciding whether to engage private investigators, or forensic experts during pretrial case assessment. Great question. I'm always thinking about, when I first meet with my client throughout the deposition, throughout the discovery process, what can I do to be effective if this case were to go to trial? Or what can I do to be effective in my negotiations? And we have a private investigator that we use, and we have a list of experts. One of the biggest things on deciding whether to do that is costs. So if your client's indigent for cost, is it going to get approved by the court? Or two, can your client afford a private investigator? And if so, for how long? There's definitely times where I want a private investigator to spend 50 hours on a case, but the client can only afford an hour or two. So definitely want to use it, especially for impeachment materials, and private investigators are amazing. They can find a lot of things. They can go out and take witness statements that the state attorney didn't get. The sooner a client reached out to you after a case happened, the sooner you can start gathering those evidence. The more serious the case, the more quickly I am to have my private investigator go out and get witness statements of people that either the state's already spoken to or people I don't know if the state's spoken to, and make sure we preserve that evidence. Same for forensic experts. I mean, It really depends on the case. You can have a misdemeanor DUI trial or a misdemeanor battery trial where you don't need an expert. But I had a battery by strangulation case where the victim was arguing she was strangled, and we called up an expert to refute that and go over her medical records and the photos and say, look, that's based off my training and experience and within a reasonable degree of scientific certainty, those are strangulation marks. So it all just depends, obviously, on can an expert or a private investigator help your defense? Are they going to hurt you? And do you have a way of affording it either through indigency for costs or through your client privately being able to pay for that? Next question, interrogatories, depositions, subpoenas are more effective for uncovering critical evidence. So again, every jurisdiction is different. So in Florida for criminal cases, we don't get interrogatories. We do get depositions on felonies and misdemeanor cases, depending on the case and the judge. But of those, and we can do motions for subpoenas. So in Florida for criminal, we have to motion the court for a subpoena. We don't have subpoena power without it. And again, depending on the case is depending on what's going to happen. All three of those, interrogatories, depositions, and subpoenas, though, the other side's going to find out what you're asking about. So the pros and cons to that. Anytime you're subpoenaing that information, the state attorney is going to be aware of what you're subpoenaing, and they're usually going to be able to get a copy of it themselves or know where you're going. Questions you ask in deposition, a smart state attorney will know why you're asking specific questions and know where you're going. Which is just, you got to think about that strategy. Do you have an open and obvious defense, or is your defense that you're waiting and you're bringing out the day of trial? And same for interrogatories. Next question. Missteps such as failing to preserve digital evidence or improperly handling witness statements negatively impact the trial? Definitely. So let's say there's a piece of digital evidence that you want to get in. So they introduce part of your client's statement that they redacted, and you have the other part. The other part's really good, and you don't have it on a USB or a CD or a way that the judge will let you introduce it. Well, you now cannot get that piece of evidence in. You also got to think about, how was that evidence given to you? So a lot of times we get a link for digital evidence and we have to download it. And if we don't download it within 30 days, it's deleted. So even if you watch that piece of evidence one time, but you don't have it downloaded and saved, you now can't go back and rewatch that piece of evidence or look at that digital evidence again during trial because you deleted your copy. So again, that's why I have this master port that hooks into my computer. It has a USB, an HDMI, a USB-C. It has all the different plugins. There's no plugin that a court's going to have that's not going to let me plug my laptop in. I always want to be prepared. I always have my laptop and my charger. So that way, if I have to present digital evidence, I'm ready to do so. And if it's my digital evidence, I've made sure that the state attorney is on notice that I'm introducing that digital evidence and that I know how to. So maybe you go to court early that day, or you go a couple days earlier and you ask the bailiff or you ask the public defender or the state attorney in that courtroom, hey, how do I use the technology in this courtroom? Because it does change. Even in the same jurisdiction, different courtrooms will have different ways and different hookups. And the last thing you want to look like is someone who doesn't know what they're doing in front of the jury. You want everything to go as a movie. You want it to look as everything you're doing is natural. How can attorneys strategically time depositions and document requests to maximize pressure on opposing counsel while maintaining compliance with the procedural deadlines? Again, it's going to be case by case specific, but typically my rule is I do not want to take a deposition of a witness until I know I have all their statements, anything that they said on body worn camera, and anything like that. But luckily in Florida, we have the rights to speedy trial rules as everywhere else does. They may be changing, but there still are rights to speedy trial. So if you want to make sure that you are, keeping the state's feet to their fire, you don't waive your rights to speedy trial, and you can't. And most times you can try to get your depositions done in time. There have been times where you have to file a motion to compel deposition dates. So a lot of times state attorneys will be very hard to set depositions with just because of their schedules. Some won't set them on Fridays. They're in court all morning. They have an FA trial schedule, and they're not offering your depo date for 4. We don't want to wait speedy. And they're not accommodating you, then you got to file a motion sometimes. You always want to try to resolve it, pick up the phone, call them before you file a motion for something like that. But that's a way to maximize pressure. Again, you want to make sure that everything you're doing is with the proper intent. So you don't want to file a motion to compel depositions and then they give you a date and then you reschedule the deposition because you're not ready because you missed a piece of evidence. So always be mindful when doing something like that. In high stakes litigation, how can attorneys balance the need for aggressive discovery with the risk of judicial pushback for excessive or burdensome requests? I mean, that's our job. It's to find that perfect balancing act. You got to set realistic expectations with your clients as well. In Florida, when we file a demand for discovery, the rule says that you have 15 days from the date of your demand after the case is filed for you to get the discovery. I tell my clients, on the 16th day on a serious case, don't expect discovery. The more serious the case, the longer evidence is going to be flowing in after your discovery demand. You want to make sure in depositions on serious cases where you have them that you're going to be getting, asking witnesses, hey, is this your report? Yeah. Okay. Other than this report, did you write any other reports? Yeah. You did? Did you turn it over to the state? I don't know. State, do you have a copy of it? No. Okay. Well, can you turn it over to the state? Let's take a recess, review it, decide if you're going to go forward with the deposition that day, or if you're canceling it and redoing it, or if you're going to go forward with it and suspend it halfway through so that we can ask about the new topics. You're always, especially in criminal, you are always going to be walking the tight line between how aggressive do I want to be versus what's in my client's best interest. And filing motions to compel every day, filing voluminous motions that is going to annoy the judge and prosecutor isn't always in their best interest, even if they're legally sounding. That's a great question. So I'm going to conclude with you guys on this page. On the next page is my URL code. So you can scan that with your phones. It'll give you all of our information. My email should be in there in case it's not. It's scott@rossenlawfirm.com. That's SCOTT@ROSSENLAWFIRM.com. If you have any questions, again, reach out to the program. They'll send it over to me or reach out to me directly. I'm happy to help anyone with any trial strategy that you may have. Anything that I can be of help to you guys, I'm glad to do it. Thank you guys for your time and look forward to seeing you guys next time. Thank you.